You see, Patty, can you hear me?
I can hear
Yes.
you.
I have no issues.
No issues? Okay, awesome.
Yeah.
Thank you.
Sounds good.
Good morning. I know it's 8 minutes before 11, but I'd like to get started as early as we can because we had a 2-hour delay. And we have 44 cases to get through. So my name is Gregory Chikalian. I am the hearing examiner for the Oil Conservation Division. It is Thursday. It is our regular docket. We are hearing cases by affidavit today. Our first case had a last minute protest, but I'm going to call it anyway. It is 25757. Entries, please.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Targa Midstream.
Morning. Who protested?
Devin did, and I see Mr. Savage online, but it looks like he's muted.
Good morning, Mr. Hearing Examiner Darian Savage with Aberdeen Shield on behalf of Devon Energy Production Company, LP.
Good morning. You protested?
Yes.
Can you tell me why?
I wasn't notified yesterday by Devon. They had just received notice of this, and they stated that the depths targeted, they have a number of wells, producing wells in this vicinity, and they also have development plans for future wells. And they had concerns. They saw that the depths targeted would negatively impact the mechanical integrity of the wells and affect production.
Okay. Ms. Hardy, how do you want to proceed?
Mr. Examiner, Targa is working and meeting with Devon to try to resolve these issues. They regularly work with Devon. And so what I would propose is that we have another status conference on December 18th to give the party some time to talk. And at this point, I don't think we need to set a contested hearing.
Perfect. Will you move your case to December 18 for a status conference?
Yes, I will.
Thank you. Anything else, Mr. Savage?
No, thank you.
All right. I'm going to ask that the parties keep their presentations as succinctly as possible so that we can get to the issues that we have with a few cases. Many of these cases can be taken under advisement. I've already reviewed these with the technical examiner. So that's the good news here. So let's go to number 2, XTO Energy 25655.
Thank you, Mr. Chikalian. This is James Parrott with Beatty and Wozniak representing XTO Energy, Inc. Case number 25655. This is an application to establish a standard horizontal spacing unit and pool with 2 wells committed in the Wildcat Bone Spring Pool. It's about 770 acres. I'll note the southernmost section is a state border section, and so rather than being the typical 640 acres, it's a little less than half that. Given your advisory before I started talking, I would be happy to skip an explanation of each and every exhibit and cover any specific exhibits that you find to be particularly interesting. Or if you prefer me just to go through each exhibit as kind of standard practice, I'm happy to do that as well.
No, we don't need you to go through every exhibit. We have them. They've been reviewed. Let's get them into evidence. So why don't you move whatever you have into evidence?
Certainly. We have exhibits A through E along with the pooling checklist. Move those to be admitted into the record.
Okay, without objection. Thank you, Mr. Parrott, and good morning to you, by the way. Mr. Technical Examiner, do you have any questions in this case?
I just now joined the meeting, but I don't believe I do. It's the XTO case we're talking about.
Yes, sir. This is the second case on our docket, 25655, and I apologize that we started earlier and you didn't know.
No, Bicky, and Mr. Hearing Examiner, I do not have any questions in this case.
All right, Mr. Parrott, good news. Your case is taken under advisement. Thank you.
Thank you. Have a great day.
Yes, you too, sir. Okay, let's call number 3 and 4, Cimarex Energy, 2568485.
Good morning, Mr. Hearing Examiner. Ben Holliday on behalf of the applicant, Cimarex Energy Company of Colorado.
Good morning, Mr. Holliday.
So these were admitted exhibit packets filed primarily to cure a publication notice concern. We put our cover pages, standard cover pages outlining those changes that were made to the exhibit packet and filed them last week.
Perfect. We'll accept those into evidence without objection. Mr. McClure.
No questions, Mr. Hearing Examiner.
Thank you, Mr. Holliday. They're taken under advisement.
Thank you all.
Let's move on to some cases. Matador Production, they 25697, 25699.
Mr. Examiner, Jim Bruce, representing applicant.
Yes, sir.
I am unaware of any other appearances.
Okay.
Mr. Examiner, in these cases, Matador, or excuse me, MRC Permian seeks to pool separately the Bone Spring Formation and the Wolfcamp Formation in the west half of Section 17, 24 South, 34 East. These are to drill several wells. These are U-turn wells. The exhibit package contains the usual pooling checklist, landman's affidavit, which pursuant to division requirement does contain at the end a list of the committed and uncommitted interest owners. There, besides MRC Permian, there is only one working interest owner, Chevron, who is being pooled, and then several overriding royalty owners. The geologist affidavit contains the usual exhibits, and then there's the affidavit of certified mailing. All parties but one received the green card. Those notices were mailed in October, and then the affidavit of publication cures any lack of notice to the one party, and that was filed, or I should say published, in October also. So that was timely. And with that, in each case, I move the admission of exhibits A through F and open it up to questions by the examiners.
All right, thank you, Mr. Bruce. Have your experts that drafted these self-affirmed statements, have they been admitted as experts before this division before?
I believe they have. One thing, Mr. Examiner, the landman, David Johns, had an unavoidable conflict come up just a couple of days ago, and the landman who is familiar with the land matters, who is testifying, is Addison Costley. I've never dealt with that landman, so I can't say for a fact that he
Okay.
is. I believe the geologist has been qualified.
Okay, all right. So your exhibits are admitted without exception. Let's get your witnesses on camera. You want to call them, Mr. Bruce?
Yes, I'm calling Addison Costley, the landman.
Yes.
And
I recognize Mr. Costley from previous hearings, so I know he's been admitted as an expert. Do we have the geologist?
Yes.
yeah, Blake Herber.
Okay, that's not a name I recognize. Mr. Herber, have you been admitted as an expert in geology before this division?
I have.
You have, excellent. Okay, so Mr. McClure, do you have questions for either one or both?
I believe Mr. Bruce may be able to resolve my questions. Otherwise, possibly I might have questions for the landman.
Okay, go right ahead.
Mr. Bruce, it appears that there may have been two separate notices provided to the Aller, or I'm probably saying it wrong, but it's like Aller Company. Are you familiar with?
Yeah,
I'm
Mr.
sorry, what?
Examiner, I did send out notice on August 15th to everyone, and then subsequently MRC said, and one of those parties notified was an ALAR entity, and then this is the main entity. They just wanted to be safe to make sure that they had notified the correct overriding royalty owner, and I sent that notice out on November 1, which is timely.
Okay, and that was going to be my next question, is when that was conducted. Regarding your CPAC,
Yeah.
you say that the spacing unit is not standard. Was that your intent? Because everywhere else in the application, it appears to be listed as standard.
Oh, I'm sorry if I did. I made a mistake. It is.
Yeah, I was going to say
Oh,
directly what it,
Yeah,
Yeah, it seems-
I see now. It is, I think it is a standard unit. It's just the U-turn wells are kind of a different deal. That's all.
yeah, and I was kind of wondering if that was kind of the reason for that.
And
If
I could correct that today and refile if necessary.
I am going to want it to be refiled, to, assuming we're all in agreement that you believe it's a standard horizontal spacing unit, then yeah, I want that to be changed to yes. And I don't think we really need to mention the U-turn, I guess, aspect of it.
Okay. Thank you.
And Mr. Hearing Examiner, that is, I'm just checking my note for the other case. I believe that resolves all the questions I had for these two cases.
So, Mr. McClure, do you want amended exhibit packets for both cases or just one?
Both cases, Mr. Hearing Examiner.
Both cases. Is that going to be subject to your further review?
I kind of know what he's going to put on there, but I think just to stick with our current, how we've
Okay.
typically been doing it would be a continuance though.
Okay, sounds good. Mr. McClure, would that be something that we could add to the December 18 status conference docket, or would that require more review or questions than I'm anticipating?
I would be fine if you're fine putting on the status conference, I'd be fine with us putting it there.
Yeah, I'd like to keep the cases moving if we can. That's great. So, Mr. Bruce, please file the amended exhibit packet with cover letter for both cases, and then continue your cases. As a courtesy, the division will hear it on the status conference docket December 18, if that works for you.
Yes, it does, Mr. Examiner. And both of the pooling checklists are in part one of my two-part exhibits. Could I just correct the part one
Sure.
on each packet?
Yes, sir.
Thank you.
All right, we're off the record in those two cases. Let's go to 3R operating 25707.
Yes, good morning. Jackie McLean with Hardy McLean on behalf of 3R Operating, and there are no other entries of appearance.
Thank you.
And in case 25707, 3R seeks to pool all uncommitted interest in the Woodford Formation in the west half of sections 28 and 21, Township 26 South, Range 27 East in Lee County, and to dedicate the unit to the Pioneer 2128 FedCom 951H well. The exhibit packets that were submitted include the testimony of landman Kyle Mendez, who has not previously testified before the division. So I'd like to request that he be recognized as an expert, and if necessary, he can be on call to answer any questions.
And that's your landman?
Correct.
All right. So, Mr. McClure, since we're on a time constraint today, do you have questions for their landman? If so, I'll get him qualified and sworn in.
I'll have questions for the geologists regarding the landman, though. We should be fine on the landman. I don't think I have any questions for the landman.
So, Ms. McLean, normally I would go through the trouble of getting them qualified, but we're on a time thing, so I'm not going to do it today.
Okay, that's fine. Then if there's questions for the geologist, first I'd ask that the exhibits be admitted for case number 25707, and then we can get him for questions.
Okay, without exception, your exhibits are admitted into evidence. And who is you want to call your geologist?
Yes, Mr. Brian Atwell. And he has previously testified before the
Perfect, thank you.
division.
Mr. Atwell, would you raise your right hand, please?
Yes, sir.
Perfect, I can see you now. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, nothing but truth?
I do.
All right, thank you, sir. This is not the best connection, just so you know, but Mr. McClure, go right ahead.
Thank you, Mr. Hearing Examiner. Mr. Atwell, I'm looking at your cross section that you have included in your exhibit B4.
Would you like me to put this on the screen?
It doesn't
thank
matter to, oh, I can Mr.
you.
if he wants it, yeah.
Thank you, Mr. McClure. And Mr. Atwell, if you want to turn off your camera, you're more than welcome to. You might have a better connection if you do.
Okay. Try that. And sorry about that. I had a terrible connection here.
I can see that. All right, go right ahead, Mr. McClure.
Thank you, Mr. Hearing Examiner. Mr. Atwell, I'm looking at the depths on that right-hand track.
Yeah.
I can't really make them out. If I were to ask you to provide us with a higher resolution image of this, do you understand what I'm asking for?
A higher resolution image on what exhibit, sir?
This is exhibit B4. It's your cross section.
Oh, before the cost section. Yes, I can provide that in a better resolution.
Okay, very good. Now it appears that you believe your completion is going to be an oil producing well. Is that correct?
Correct.
Do you have any what information, I guess, are you basing it of it being oil rather than gas, I guess?
That information is coming largely from development that's going on in Texas across the border in Andrews County. Continental has brought on wells at similar TVD, and they're classified as oil wells and producing as oil wells. And so that's the information we're used for that assessment.
What is the GOR of the GOR of those wells?
There are 1,000 to 2,000 GOR at that TVD.
And the units for that is cubic feet per barrel, or is that MCF per barrel?
That is cubic feet per barrel.
Okay. So then you would imagine then that this is going to be very similar then, is that correct?
Yes, yes, based on the information we have at the time, that is our expectation.
Okay, sounds very good. Just for your awareness, I believe once the APD gets approved, we'll probably be issuing a condition of approval that we will be looking at the GOR for this well. The reason I bring it up is if it does turn out that this well is gas, then we may have to end up revisiting any orders that get issued from this case. And I wanted to make sure that 3R was aware of that possibility. Do you understand what everything I just laid out?
We'll comply with any reevaluation at that time.
Okay, sounds very good. Thank you, Mr. Atwell.
Or is that just the witness?
I'm sorry, Mr. Hearing Examiner, I didn't catch that. Mr. Hearing Examiner, can you hear me?
It looks frozen.
I can hear you, Mr. McClure, but
Yeah, I'm wondering if maybe Pecos Hall might be.
Mr. McClure.
Oh, I can hear you now, Mr. Hearing Examiner. Go ahead.
Okay, all right. Well, we're going to take a 1-minute break, and the minute break is over, so let's continue. Mr. McClure, does that finish your questions for this case?
It finishes my questions for the expert, but I do have guidance for Ms. McLean on this.
She's right there. Go right ahead.
Ms. McLean, on your CPAC, where you reference a pool.
Yes.
This is the incorrect pool. There is not a pool even close to this area. So if we can correct that to just simply Wildcat Woodford and do not include an actual pool name or pool code, because that's something our district geologist will have to assign once we receive the APD for this well.
All right. We can do that.
All right. So, Mr. McClure, it sounds like this case is coming back for additional review once you get your clarified Exhibit B4.
That's correct, Mr. Hearing Examiner.
All right. So, Ms. McLean, how long will it take you to provide that?
It would just depend on Mr. Atwell getting me that exhibit, but I don't imagine it will take beyond the end of the week.
You want to try for December 18?
Yeah, that would be wonderful.
All right. And you'll have your CPAC corrected as well?
Yes.
All right. Would you affix a cover letter to that?
And then I think we would also need to change the C-102
Okay.
to take off the pool and pool code.
That's your prerogative. So, Ms. McLean,
So we will continue to December 18th.
you're going to continue it to December 18. And please affix a cover letter to explain what you're changing.
Will do. Thank
All
you.
right, thank you. We're off the record in that case. Let's move on to Tap Rock Operating. This is number 825710.
Good morning, Mr. Examiner. Miguel Suazo with Beatty and Wozniak, appearing today on behalf of Tap Rock Operating.
Good morning, Mr. Suazo. Let's keep it succinct.
Sure. In this case, Tap Rock seeking an application to approve a standard horizontal spacing unit. What's notable is that this is seeking to amend Order 23945 after Tap Rock determined that there were uncommitted and unleased mineral interest owners in their Beer 30 FedCom unit who were not originally pooled. They identified that the New Mexico Department of Transportation owns a small unleased mineral interest in the unit. And we have the standard suite of exhibits. Exhibit A is the application. Exhibit B is the original pooling order. Exhibit C is the affidavit from Tap Rock senior lineman Erica Shoemaker, who has testified previously. And Exhibit D is the notice affidavit indicating that notice letters were mailed on October 22nd, 2025. Unless the division requires any additional detail or questions, I would ask that this matter be taken under advisement and that the exhibits be admitted into the record.
Thank you, Mr. Suazo. Admitted without exception. Mr. McClure, is this case good to go?
Yes, it is, Mr. Hearing Examiner.
All right, we'll take it under advisement. We're off the record.
Thank you.
Let's move on to case number 925711, Burke Royalty.
Good morning, Mr. Hearing Examiner. Yaritza Pena with High Plains Natural Resources.
Thank you.
I don't believe that there are any other parties in this case.
Right ahead.
In this case, High Plains is a successor in interest to Stewart Energy and is seeking a one-year extension until October 20th, 2026 to commence drilling the wells. Good cause exists for this one-year extension as High Plains' ability to commence drilling the wells has been impacted by High Plains' acquisition of Stewart's assets. We timely filed exhibits last week and include the testimony of and corresponding exhibits of Josh Moran, who has not previously testified before the division, and we would seek to have him recognized as an expert.
Is he the landman?
He is the landman.
What's his name?
Josh Moran.
Can we get him on the screen?
Yes, sir.
Excellent. Mr. McClure, are you going to have questions for the landman?
Yes, I will, Mr. Hearing Examiner.
All right, let's get him qualified then. Let me interrupt your presentation, Ms. Pena. Once I can see him, there we go. Okay. All right, Mr. Moran, please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
Yes, sir.
Spell your name for the record.
JOSHMORIAN.
And you seeking to be qualified as an expert in what field?
Land.
Okay. Can you briefly review your education and experience that goes to that qualification?
Yes, sir. I have a Bachelor of Science degree in bioenvironmental science from Texas A&M University. Graduated in 2008. I've been a practicing landman for the past 17 years. The past 10 of those years have been for Burke Royalty as an in-house landman.
What are your duties?
To oversee the development of leases, oversee the development of well schedules, drilling, review contracts, joint operating agreements, farm outs, farm ins, surface use agreements, pipeline right-of-way easements, negotiate with surface owners, mineral owners, and non-operated working interests.
Are you a member of any professional associations?
Yes, sir. I'm a member of the American Association of Professional Landmen, and I hold a certificate from them as a certified professional landman.
Okay, you're recognized as an expert in petroleum land matters. Ms. Pena?
Thank you. In our exhibit packet, we also include our notice testimony with copies of the notice letter, the letter sent on October 24th, 2025, and the affidavit of publication on October 29th. With that, I ask that exhibits A and B be admitted into the record and that the case be taken under advisement.
Perfect, thank you. Yes, they are admitted without exception. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Moraine, I'm looking at your self-affirmed statement. Can you provide me a little bit more details in regards to your good cause for requesting an extension?
Sure. So we spent the better part of the first half of this year performing due diligence on this acquisition. We had originally intended to be the contract operator on behalf of High Plains when the deal matured such that we would actually own High Plains and would be responsible for future drilling obligations. That's when we really started to take a look at these the drilling plans that Stewart had and what it would take to get those picked back up. And so we were just caught a little flat-footed with our planning. And so that's why we're trying to take this one step at a time to make sure we understand what's expected of us, make sure that we dot all of our I's and cross all of our T's and proceed accordingly.
Okay, so are these wells now on your drilling schedule?
Yes, sir.
And when approximately do you speculate that you'll conduct or you'll start drilling?
For this well in particular?
Yes, sir.
Our drilling program is going to commence in the first quarter of 2026. This well, depending on the outcome of this hearing, will either be in the first quarter or second quarter of 2026 based on our plans right now.
Okay, thank you, Mr. Moraine. Mr. Hearing Examiner, I have no further questions for this case.
Perfect. Can we take it under advisement?
Yes, we can, Mr. Hearing Examiner.
All right, we're off the record. Thank you, Ms.
Thank
Pena.
you.
Thank you.
All right, let's move on to COG Operating 25712.
Mr. Examiner, Dana Hardy on behalf of COG Operating and MRC Delaware Resources entered an appearance in this case.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of MRC Delaware Resources, and we are just monitoring.
Perfect. Ms. Hardy?
Thank you. COG seeks to pool uncommitted interest in the Wolf Camp underlying a 640-acre standard horizontal spacing unit comprised of the east half of sections 12 and 13, Township 26 South, Range 28 East in Eddy County, and will dedicate the unit to the Tater Salad VedCom wells. Our exhibits include the land testimony and exhibits of Shelley Klingler, and she has previously been admitted to testify as an expert in petroleum land matters. And we have also provided the geology testimony and exhibits of Jessica Pontiff, who has also been previously qualified as an expert in geology before the division. And then our notice information is provided and shows that we sent timely notice by certified mail on October 15th, 2025, and published notice timely on October 25th, 2025. So with that, unless there are questions, I ask that the exhibits be admitted and that the case be taken under advisement.
Thank you, Ms. Hardy. Admitted without exception. Mr. McClure?
Mr. Hearing Examiner, I will have questions for the landman.
Okay, let's get the landman on.
I'm here.
Wonderful. Would you raise your right hand, please? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but the truth?
I do.
Spell your name, please.
Shelley, Shelley, Klingler, Klingler.
Thank you. And you've previously been admitted as an expert in what field?
Petroleum land management.
Before this division?
Yes.
Thank you, Mr. McClure.
Thank you, Mr. Hearing Examiner. Ms. Klingler, I'm looking at your exhibit A3. specifically page 30 of 63 of the exhibit packet.
30. Okay. Yes.
Are you sharing with us too, Ms. Hardy?
Let me do that. Page 33, Mr. McClure.
30 is the
30.
one I'm looking at.
Okay.
Ms. Klingler, here there's a reference of total project area working interest kind of at the
Yes.
bottom of that table. You see what I'm referring to?
Yes.
Here you have CLG entities listed out.
Yes.
Which companies are you referring to by that?
COG operating, Concho Oil and Gas.
Okay, does it CLG Production LLC, CLG Acreage? Are those included?
I think the title was showing us COG operating and Concho Oil and Gas. I'll double check on the COG production.
Well, I guess if I can direct your attention to the next page down is where I was getting those other two entities from. I don't know if that
Oh, I'm
brings
sorry.
anything to mind.
You're
for
right.
you.
Yes, I forgot for that one. Yes. Because there were 3 old operating agreements under this tater salad drilling spacing unit. So COG production and COG acreage.
Okay, so essentially those that CLD entities is referring to these 4.
Yes, sir.
Okay. Thank you, Mr. Klingler. Yeah, I think we should be good on Exhibit A3. I have no further questions for this case, Mr. Hearing Examiner, but I do have a request for Ms. Hardy on the CPAC.
Go right ahead.
Ms. Hardy, you have the setbacks listed as being statewide. Do you see where I'm referring to?
Yes.
Can we correct that to match the Purple Sage setbacks? Whether you want to say 330 or reference Purple
Yes.
Sage or reference that hearing order, however you wish to do it.
Yes, I
it's
can do
probably
that.
fine. Okay. Thank you, Ms. Hardy. Thank you, Ms. Hearing Examiner. I have nothing further for this case.
So Mr. McClure, since they're going to be resubmitting information, do you want the landman to correct that other exhibit?
I mean, we could have the landman do a breakout of those different entities. I'm assuming it's kind of under the same umbrella. But Ms. Klinger, do you have that information available to you at hand, the breakout between the 4 entities?
I can do that.
Okay, yeah, I guess if we want to submit an amended exhibit A-3 as well, that would be good.
Perfect. So Ms. Hardy, will you do that in enough time to continue this case to December 18th?
Yes, I can
All
do
right,
that.
perfect. That works for you, Mr. McClure?
Yes, it does, Mr. Hearing Examiner.
All right, very good. We're off the record in this case. Thank you, Ms. Klingler.
Thank you.
All right, Matador Production. This is number 1112 on the docket, 25713, 25714, and it looks like also 25715. Entries of appearance, please.
Good morning, Mr. Hearing Examiner, Mr. Technical Examiner Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant MRC Permian Company. And I believe there's one party that entered an appearance.
She's trying. It's having trouble with the microphone.
Okay.
And hi, Caitlin Luck, appearing this morning for Vicky Meadows and Bo Bays, and there's no objection to this case, just simply appearing and preserving rights.
All right, perfect. Go right ahead, Ms. Vance. You want to present them all together, please?
Yes, and I will be very brief.
Thank
So
you.
in case 25713 and 25714, those are our 2 bone spring cases, and they are standard spacing units. And then our case 25715 is our Wolf Camp case. That is a Wolf Camp oil, and again, it's a standard spacing. Our experts are Hawks Holder is the landman, and our geologist is Andrew Parker. both of whom have previously testified before the division. We've included all the standard exhibits, including the CPAC and a copy of the filed application. And then, of course, my self-affirmed statement of notice and our notice of publication. All notice was timely. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time.
Thank you, Ms. Vance. Ms. Luck?
No objection, thank you.
All right, without exception, Ms. Vance, Mr. McClure.
Mr. Hearing Examiner, I have no questions for the witnesses, but a request for Ms. Vance on the Bone Spring cases.
And what case numbers are those?
The first two that will
Okay.
be,
Got it. 1-3 and 1-4. Go right ahead. So in other words, we can take 1-5 under advisement?
that is correct, Mr. Hearing Examiner.
All right, go right ahead.
Ms. Vance, for the Bone Spring cases, there's only one Bone Spring pool in the area. So if we can correct the CPAC and the Form C-102 to reflect that the pool is your Salt Lake Bone Spring pool code 53560.
Okay. And I would just ask the same courtesy that we are able to continue this to the 18th, and we will file those revised hearing packets and have these taken under advisement at that time. Would that
Yes,
be
Ms. Vance.
appropriate?
Yes, Ms. Vance, that's granted. So we'll see these two cases on December 18 when you file your amended exhibit packet with cover letter and continue them.
Thank you.
All right, so we're off the record in those three cases. Let's move on to Permian Resources. Looks like we have a bunch of cases here. I'm going to read the case numbers: 25719, 20, 21, 23, 24, and 25. Entries, please.
Good morning, Mr. Hearing Examiner. Yoditza Pena on behalf of Permian Resources Operating.
Yes, ma'am.
And good morning again, Mr. Hearing Examiner. Caitlin Locke appearing in this case for WR Non-Op LLC and on all 6 cases, sorry.
And your position?
Oh, no objection, just preserving rights. Thank you.
Perfect. Thank you.
Thank you. Mr. Hearing Examiner, in all of these 6 cases, Permian is seeking a 1-year extension of time until February 19th, 2027. All these orders pooled uncommitted interest in the Bone Spring and Wolfcamp formations in sections 11 and 14 in Township 20 South, Range 33 East in Lee County, and dedicated the various spacing units to the Anaconda Federal Commonwealths. Our exhibit packet includes the land testimony and corresponding exhibits of Mark Kajic, who has previously testified before the division and has been recognized as an expert in petroleum land matters. And we also include our notice testimony with copies of the notice letter that was sent to all parties on October 20th, 2025, and the affidavit of publication on October 29th, 2025. With that, I ask that all the exhibit packets be admitted into each case and that the cases be taken under advisement.
Sounds good. I don't think Mr. McClure has questions on these cases, so let me just ask you myself, after admitting your exhibits without exception, what is the good cause to grant the extension?
So Permian seeks this extension because they have been impacted by permitting delays and the rig availability in the area.
Okay. All right. Mr. McClure, that's sufficient?
Yes, it is, Mr. Hearing Examiner.
All right, Ms. Pena, these cases are taken under advisement.
Thank you.
Thank you. Move on to Mewbourne Oil 25726.
Mr. Examiner, Dana Hardy on behalf of Mewbourne Oil Company.
Go right ahead.
Thank you. In this case, Mewbourne seeks an extension of time to commence drilling operations under Order R23512 and also to amend the order to add or correct the pool name and code. After the original order was received, OCD notified Mewbourne that the pool needed to be changed. And because this was a non-standard spacing unit, we needed to apply for a hearing to do that. So those are the requests, and we have provided the self-affirmed statements of Landman Braxton Blanford, who has previously testified before the division. And our notice information shows that notice was timely provided and published. So with that, I would ask that the exhibits be admitted and that the case be taken under advisement.
Thank you, Ms. Hardy. Without exception, Mr. McClure, questions on this case?
Mr. Hearing Examiner, no questions, but some requests for Ms. Hardy.
Go right ahead.
Ms. Hardy, the original CPAC or I should say the CPAC that is associated with the original order. Can you update that to have the correct pool on it and provide us with the amended CPAC?
Sure, we can do that.
Okay, and then one additional request. I know the division's been requesting for our NSP applications, if we could identify the interests in each of the surrounding tracks. Do you understand what I'm asking for by that, Ms. Hardy, I guess?
Yes, and I believe that we had done that in our Exhibit A3.
Yeah, I was gonna say, looking at the A3, you have the affected tracks identified, but you don't have the owners listed there for each of the tracks.
I see the owners are listed on the next page, but it's not by tract. So
My
Yes.
understanding is the division's been requesting that we
Okay.
provide that for each of the identified tracks rather than just a blanket list.
Okay, we can do that.
Ms. Hardy, December 18th,
That's fine.
it gives you enough time?
Yes, thank you.
All right. Mr. McClure, December 18th looks like it's going to be busier than we thought originally.
Well, it
All right.
should be pretty fast, I hope, though, regardless.
Hopefully,
But-
yes, we all hope, share in that hope. All right, so we're off the record in that case. Let's go on to Matador. There are a number of cases here. I'm going to call them 21 through 29 on our dockets. They are case numbers 257, 28, 30, 31, 32, 33, 34, 35, 36, and 37.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant MRC Permian Company.
Thank you. Don't we have another party?
Yes, EOG made an appearance in some of these cases.
Ah, okay. Would that be Jordan Kessler?
It would be, but I am not.
Okay, that's fine.
seeing
That's
her.
fine.
Okay.
I know why she enters an appearance. It's okay. Go right ahead, Ms. Vance.
Okay, there are a couple of nuances with these, so I'll just point those out. Our bone spring cases are 25728, 3031, 3233, and that's it. We do have one other bone spring case that we did continue, but that case is on the January 8th docket. That being said, case 25728 and 25730 both involve a depth severance. They're complementing each other. So 25728 is pulling the second bone spring, and then 25730 is pulling everything except for the second bone spring. Those cases also include overlaps, overlapping approval, as well as the other bone spring cases. And then in case 25733, again, it's another depth severance that exists there. And in this particular case, it is pulling everything except for the second bone spring. And then that other case that I spoke of that we continued to the January docket pulls everything, it pulls the second bone spring. And then the other cases, case numbers 25734 through 37 are our Wolf Camp cases. And that is a oil wolf camp. We have included a copy of the application, the CPAC, and then the statements of our landman, Hawks Holder, and then our geologist, Andrew Parker, both of whom have previously testified before the division, and their credentials have been accepted as a matter of record. And then, of course, all of the required sub-exhibits for each expert. And then that is followed by our notice, including my self-affirmed statement, and then the notice of publications. And with that, unless there are any questions, I would ask that all of the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time.
Perfect, Ms. Vance. Thank you. All of your exhibits are admitted without exception. Mr. McClure, from our earlier conversation, I understand that case number 22 and 25 on the docket, you have some concerns about which cases of these can we take under advisement?
The Wolf Camp cases we can take under advisement. Those would be 734 through 737.
All right, perfect. So, Ms. Vance, you heard that, right?
Yes.
All right, so Mr. McClure, you have questions for, is it just Ms. Vance or do you have some witness questions as well?
I'll have for the two that you referenced, 730 and
733.
733. I'll have questions for the landman and geologist, preferably
Both.
geologist first. Yeah, but
Okay.
both, yeah.
What about, okay, all right, let's get them sworn in. So Ms. Vance, would you call your witnesses, please?
Yes, Mr. Hawks Holder and Mr. Andrew Parker, and they are right there.
Excellent. Okay. I see both gentlemen here. I recognize one of them, but let's get them both sworn in. Now I don't see anyone. Can we stop sharing the screen just for a moment?
Sorry about that.
That's perfect. Okay, gentlemen, would you please raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, yes.
All right, you can put your hands down. Would you spell your names individually for me?
Andrew Parker, that's AndrewParker.
Okay, and Mr. Parker, I recognize you, but I'm going to ask you anyway. What field of expertise have you been admitted before this division?
Geology.
You're the geologist. Okay, very good. And then the other gentleman, please.
Yes, Hawks Holder, HAWKSHOLDER.
And you have been admitted as an expert before this division?
I have.
In what field?
Petroleum land management.
Okay, very good. Mr. McClure, you can ask your question to the either as a panel, and whoever is qualified can answer if you like.
Yeah, that'll work for me. Thank you, Mr. Hearing Examiner. Mr. Parker, specifically, I'm looking at the two cases in which it appears Matador is requesting to requesting the division to force pull the Bone Spring, except for the Bone Spring 2. Are you familiar with which cases I'm referring to?
Can you reference the? Can we reference the well numbers in these cases, or because I'm not sure which ones have been moved on and which ones we're holding up here.
One of the case numbers would be case 25730 if you want to bring it up, Ms. Vance. Or you can do 733. That might reference it for your witnesses. If you could scroll down to the CPAC, that might give them the well numbers.
Okay, so we got 131 and 134. Okay.
Okay, so you're familiar with the instances that I'm referring to, Mr. Parker?
Yes, sir.
In this instance, is it correct that the Bone Spring 1 and the Bone Spring 3 are not directly touching?
Well, both of these wells in these two cases are targeting the third Bone Spring sand.
Is it accurate to say that Matador is requesting the division to force pull interest in the upper Bone Spring as well as the Bone Spring 3?
To my knowledge, we're asking to pull the entire Bone Spring formation, which includes, all of the Bone Spring sands, first, second, and third Bone Spring sands. But for these two wells, we will be targeting the third Bone Spring sand.
Mr. Holder, did you hear the question I just asked Mr. Parker?
I did.
Is it accurate that Matador is requesting to force pull, I guess, the entirety of the Bone Spring except for the Bone Spring 2 in these two cases?
That's correct.
Okay. Mr. Parker, did you just hear what Mr. Holder responded?
Yes, yeah, I understand now.
So is it accurate to say that the Bone Spring 1 is not directly connected to the Bone Spring 3?
You're talking about the first Bone Spring sand?
That's correct, Mr. Parker.
Yes, it's not touching or connected to the third Bone Spring.
And are these two intervals separated by the Bone Spring 2?
Yes, it's in between them.
And based off of Mr. Holder's earlier response, is it also accurate to say that Matador is not including the Bone Spring 2 within this particular proposed unit?
I mean, to my knowledge, yes, I'm not, an expert on the depth severances here, but if we're excluding the second bone here, then that's separate from the third Bone Spring.
Are you aware of how hydrocarbons from the Bone Spring 1 can be produced by wells within the Bone Spring 3 without that production traversing the Bone Spring 2?
I'm not sure I understand your question.
Okay, you have two separate vertical intervals that you're asking the division to force pull. But there's another vertical interval, the Bone Spring 2, that separates those two vertical intervals. My question to you, how is Matador proposing to produce from that upper vertical interval without it going through the middle interval?
I guess I'm confused because we're not talking about producing from the first Bone Spring in this well.
However, Matador is asking the division to force pull the Bone Spring 1, correct?
Well, I mean, we're force pulling the Bone Spring formation, yes.
Mr. Holder, why is Matador requesting the division to force pull the entirety of the Bone Spring except for the Bone Spring 2 when it can't produce the Bone Spring 1 via its proposed wells?
So it's because of the depth separate.
Okay, let me re-ask my question. Considering that the normal avenue would be to pool these in two separate cases, why did Matador ask to force pool these two separate intervals in a singular case? If you don't know the answer, that's fine too, Mr. Holder.
I think you just cut out. We lost probably the last 15 to 30 seconds.
Do you want me to re-ask my question?
Yes, please.
Okay, considering that the normal avenue is to pool, would be to pool the two separate vertical intervals in two separate cases, why is Matador asking the division to force pool them in a singular case in this instance?
I would defer to counsel on that.
Mr. Hearing Examiner, I don't think I have anything further for the experts, but I do have questions for Ms. Vance.
All right, now, just to be clear, Ms. Vance is not a witness who has been sworn in, so she can't provide, evidence the way the landman or the geologist can, but go right ahead.
Okay, yeah, I guess maybe I don't necessarily have questions for Ms. Vance.
I think she wants to say something, so go right ahead.
Would it be possible for me to ask my own witnesses some questions that might help Mr. McClure?
Go right ahead, Ms. Vance.
Mr. Holder, and I don't see you up, is the interest the same between the first and the third bone spring?
Yes, it is.
And is the interest different specifically for the second bone spring?
It is.
Okay. So, sorry, I'm getting some feedback from, I think, Ms. Shaheen. Sorry, I was hearing a lot of noise. And then for the wells that are proposed for the bone spring cases, what is the specific target for those wells?
On the bone spring cases,
Yes,
are you referencing the second bone spring only case or the first and third bone spring case?
the first and third bone spring cases.
The specific and the target of the initial wells right now would be the third bone spring.
Okay, and does Matador plan to come back and do infill wells in the first bone spring?
Yes, we do.
Okay, sorry, I don't know why Miss Shaheen's keeps getting unmuted. And you plan to drill those first bone spring wells under the proposed order, correct?
That's correct.
No further questions.
Mr. McClure, do you have any follow-up to those questions?
I do not, Mr. Hearing Examiner.
All right. How do you want to proceed, Mr. McClure?
I want to provide some guidance for Ms. Vance, if I may.
Go right ahead.
Ms. Vance, I guess first directing my attention to the two cases that we're talking about, or the primary ones that we had questions about, that being case 730 and case 733. We kind of have two options here. The division will not be approving them as they currently are presented. You may allow us to go ahead and reject it if you'd like, but your other option would be to dismiss yourself the interval, one of those intervals, presumably your upper portion of the bone spring, and then receive a compulsory pooling order for just the bone spring 3 if you'd like.
If we could just take a pause from these cases and let me just check with my client, but that was going to be my follow-up to suggest that was going along with your questioning. If I could have just a moment, I actually am presenting the next cases, but if I could just have a moment to discuss with my client and follow up before the end of the hearing, could I do that, please?
I'm okay with that. So Ms. Vance, you're saying that you are presenting the Hillcorp Energy cases?
Yes, I am.
All right. And then, so are you prepared to proceed now on the Hillcorp cases and then follow up with your client?
Yes, and actually I've got the one last case after that.
Perfect.
And I know I may even get an email while I'm presenting to
Okay.
confirm how Matador would like to proceed. But that would be, I can definitely let the division know
Okay.
whether or not we'd like to proceed how Mr. McClure has laid it out.
Okay. So Ms. Vance, we have taken certain cases in the Wolf Camp under advisement. You know that.
Yes.
All right, very good. All right, why don't you, then we're in recess on the other cases in the Bone Spring for now until you get some direction from your client. Let's move on to Hillcorp Energy cases. These are number 30 through 37 on our docket. Case numbers 25738, 3940, 41, 42, 43, 44, and 45. Entries, please.
You know what? I already got an answer. Could I mean, however you would like to do it.
Let's go
Mr.
back on the
Examiner.
record to Matador cases. Go right ahead, Ms. Vance.
Okay, we will go ahead and dismiss the first bone spring portion and move forward with the third bone spring. We'll come back with separate applications to pool the first bone spring portion of those two cases. So for case 25730 and 25733, we would just request to pool the third Bone Spring for those initial wells that are included with the application.
So, Mr. McClure, how does that, so first of all, how does that affect case number 257-283132?
That specifically will not affect those three cases, Mr. Hearing Examiner.
Okay, so do we need something else on those cases I just listed?
That is correct, Mr. Hearing Examiner. For all 5 of the Bone Spring, I have further guidance for Ms. Vance.
Okay, now, so before you give Ms. Vance some guidance, Ms. Vance, are you going to submit a formal document dismissing part of your case, your application? Is that what you're going to do?
My thought was, and I was kind of wondering what guidance Mr. McClure was going to provide, but my thought was going to be to just go ahead and file a revised hearing packet with an updated CPAC that just provides for pooling that third Bone Spring portion of the filed application. Rather than, and we can, and I can include a description in the cover page per the usual process.
So Ms. Vance, if I understand you correctly, notice will not be affected because you're basically contracting the area that you are asking the division to force pool.
Yes, I think because we have provided for more than what we are now going to pool, it just would be a matter of revising and conforming to what the division will allow us to pool based on Mr. McClure's guidance.
All right, Mr. McClure, do you want to give Ms. Vance guidance on these 5 Bone Spring cases?
Yes, I will. Thank you, Mr. Hearing Examiner. Ms. Vance, similar to the earlier cases, we have an additional pool that is not correct. The Bone Spring should be in its entirety is in the Salt Lake Bone Spring pool code 53560.
Okay.
So if we can correct the CPACs and Form C102s to reflect that in all 5 of the Bone Spring.
We'll do that.
And that's all I had, Mr. Hearing Examiner.
Okay, so now Ms. Vance, with what you understand, what are you submitting and when do you want to bring these cases back?
I would venture to guess that we will be prepared to come back by the 18th, and we will file revised hearing packets to account for the just the one pool for all of the Bone Spring cases, and then for the case 25730 and 25733, we will revise the CPACs there to account for just the pooled portion of the third Bone Spring. Per Mr. McClure's guidance.
All right, perfect. So it sounds like your client has some direction forward with these 5 cases. We'll come back on the 18th once you continue them and file the proper documents and hear them at that time. So we're off the record there. I think I called your Hillcorp Energy cases, Ms. Vance.
Yes, and if you give me just 1 second, I've got a lot of papers in front of me. Good morning, Mr. Hearing Examiner, Mr. McClure. Paula Vance with the Santa Fe Office of Holland and Hart on behalf of the applicant, Hillcorp Energy Company, and there are no other parties in these cases.
Go right ahead.
Okay, in all of these cases, Hillcorp is requesting an exception to the well density requirements. In case numbers 25738 through 25740, that involves the Blanco Mesa Verde gas pool, and that gas pool code is 72319. And then in case numbers 25741 and 25745, this is a request from the request for an exception for the Basin Dakota gas pool, and that pool code is 2521599. And I won't go through all of the specifics so that we can keep things moving along. But in each of the hearing packets, we did provide a statement from our landman, Gatewood Brown, who has previously testified before the division, and his credentials have been accepted as a matter of record. And then also our reservoir engineer, Mr. Marcus Hill, who has also previously testified, and his credentials have been accepted as a matter of record. I will, and then we've included the required sub-exhibits for both of our experts. And then that's followed by my self-affirmed statement of notice, along with the notice of publication. I will point out that I did file a revised hearing packet this morning in case 25742, because I noticed a copy of the a sample copy of the notice letter was missing from the hearing packet. So that did make it into the record, and we did provide include a cover page for that. Unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time.
Thank you, Ms. Vance. Without exception, Mr. McClure, I believe these cases were going to be taken under advisement, but now you've heard something is missing.
I believe we can still take it under advisement, provided that we're fine with accepting that amended exhibit from this morning.
Ms. Vance, when can you get that to us?
It was already filed.
Oh, it's already filed.
It's
Okay.
already filed, and it
In
was
all-
approved. It's in the it's in the case file.
For all of these.
It was just for the one case,
Okay.
25742. It was just the sample copy of my notice letter. For whatever reason, just it was missing.
Very good. Okay, then thank you, Ms. Vance. Freya, can you verify that in case 25742, we have that additional filing?
We do.
Excellent. Ms. Vance, we'll take these cases under advisement.
Thank you very much.
Moving on to Matador Production, 25749.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MRC Permian Company. There are no other parties in this case that I know of, and this is just a request for extension. And we have included a copy of the application, the original order, our statement from our landman, Hawks Holder. There's a paragraph 5 has a talks about the good cause for the request. And then we've included all of the required notice, including my self-affirmed statement of notice. And unless there are any questions, I would ask that the exhibits be admitted into the record and that this case be taken under advisement at this time.
Admitted without exception, and the case is taken under advisement. Thank you. Let's move on to Mewborn Oil, 25751 and 52.
Oh, good morning. For one more minute, Mr. Hearing Examiner, Rayleigh Starnes with the Santa Fe office of Holland and Hart.
Would you spell your name?
Yes, Rayleigh, Raylee, Starnes, Starnes.
Starnes, thank you.
Yes, on behalf of the applicant, Mewborn Oil Company, and I don't believe there are any other appearances in this case. Case numbers 25751 and 25752 are both seeking pooling orders for acreage in the Bone Spring Formation in the southeast quarter of Section 18 and the east half of Section 19, Township 18 South, Range 34 East, Lee County, New Mexico. They're both standard orders with one exception of 25751 also being an application for approval of an overlapping spacing units. We've included all of the necessary standard exhibits, including statements by Brendan Johnson, landman, and Charles Crosby, geologist. Brendan Johnson, the landman, has not previously been accepted as an expert in front of the division, and unfortunately, he did have an unavoidable conflict today. So if the technical examiner has any questions, we do have Tyler Jolly on the line just in case. But if there are not any questions, I would ask that all exhibits and sub-exhibits be admitted into the record and the cases be taken under advisement by the division at this time.
They're admitted without exception, and we'll take the two cases under advisement. Thank you.
Thank you.
And welcome. Let's move on to Permian Resources. These are two cases, 25762 and 63. Entries, please.
Good morning, good afternoon, Mr. Hearing Examiner. Yaditza Pena on behalf of Permian Resources Operating.
Thank you.
And I believe there are no other parties in this case. In these two cases, Permian Resources seeks a 1-year extension until December 12th, 2026 to commence drilling the wells authorized by the orders in the Bone Spring formations, and they're dedicated to the Star Fox 9 FedCom wells. Good cause exists for the requested extensions as Permian's ability to commence drilling the wells has been delayed due to limited rig availability and also requires additional time to evaluate offset drilling results to determine well spacing in the area. Exhibits were timely submitted for these last week and include the land testimony and corresponding exhibits of Logan Cooksey, who has not previously testified before the division. And if there are any questions, we would ask to have him admitted as an expert. We also include our notice testimony with copies of the notice letter, which was timely sent on November 11th, 2025, and the affidavit of publication for November 15th, 2025. With that, I ask that the exhibits be admitted in these two cases and that the cases be taken under advisement.
Thank you, Ms. Pena. The exhibits are admitted without exception. I don't believe we have any questions for your landman, so we're not going to qualify him or her. I didn't quite get the name today. And I believe we can take these two cases under advisement. Thank you.
Thank you.
Moving to the last two cases, now we have Mewbourne Oil 25766.
Yes, Jackie McLean on behalf of Mewbourne Oil Company.
Thank you.
And in case number 25766, Mewbourne is just seeking to pull additional interest owners under the terms of order number R23654. And they're only pulling additional leased mineral interest to satisfy certain contractual provisions within the leases. I ask that the exhibits for case number 25766 be admitted into the record and that the case be taken under advisement.
Okay. And your landman, who is your landman?
Yes, our landman in this one is Brad Dunn, and he has been admitted previously
And what
as
was
an
the name?
expert. Brad Dunn.
Brad Dunn. Okay. I have a feeling we're going to have a question for Mr. Dunn.
Okay.
Is that right, Mr. McClure?
It is, Mr. Examiner.
I thought it was. And let's get your exhibits admitted without exception, Ms. McLean. Thank you. And what about your notice? When was it mailed and published?
Our notice was mailed on November 11th and affidavit of publication November 15th.
All right. Thank you. All right. Mr. Dunn, would you please raise your right hand? You swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Perfect. Would you spell your name, please?
Brad Dunn, BradDunn.
Thank you. And you've been previously admitted as an expert in what field?
In land.
Before this division?
Yes, sir.
Perfect. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Dunn, can you provide a little bit more details about who Mewbourne is requesting the division to force pull?
Yeah, so we did a non-standard proration unit. It was approved by the OCD. And the leased mineral owners that never ratified our COM agreement that called for a spacing unit of 1,280 acres. We're seeking to pull them into this larger unit because all of their leases are from they're all these older fee leases, and they have a provision within the lease that doesn't allow for larger than a 640 acre spacing unit. Plus 10%. So this is larger than that. So we're just seeking to pull them into this larger spacing unit under the NSP. To satisfy that provision of the lease.
Now you reference NSP, but we are talking about the original order R23654. Is that correct?
Right.
Okay, so then what's the reference to the NSP about then?
The NSP expanded the proration unit to 2 full sections, so 1,280 acres. And then like I said, the lease provision from the original leases, it doesn't allow for more than 640 acres. And so we're using the same order that was issued for this larger unit to pull these leased mineral owners into the larger spacing unit.
Okay, so then you are referring to amending the compulsory pooling order, which
Right.
already had the larger spacing, is that correct?
Yes. But we're adding
Okay.
these, right.
Okay, so then is it accurate to say that every additional person that Uborn is requesting the division to force pool is a mineral interest owner and has no working interest? Is that correct?
Yes, sir. That's correct.
Okay, and I'm looking at the footnote that's in your exhibit A3, which seems to reference the list in A6. Do you know what I'm referring to, Mr. Dunn?
What page is this on the exhibit?
I'm looking at, well, the footnote looks like it's on page 18 of 94.
Okay, I'm there.
Okay, and you see the footnote at the bottom of this page?
Yes.
Okay, so essentially what we're trying to get at is that the actual list of the persons that Newborn's asking the division to force pool is exhibit A6. Is that correct?
Yes, that's correct.
Okay, and A6 being on page 69, it looks like.
Right.
Okay, so you see this, looks like this table extends across 2 pages here. You see what I'm looking at, Mr. Dunn?
Yes, I'm here.
Is it accurate to say that every person on this list are the ones that Newborn is requesting the division to force pool?
That is correct.
It's on
Okay, with that in mind, let me look at my your exhibit A3 again.
Okay.
I'm just debating on if I want any amended exhibits to make that more clear, or if we have enough here in writing and verbal testimony. And Mr. Dunn, does your landman statement in here, does it reference the individuals or reference that table somehow as to those being the persons that Newborn's asking to be force pooled? Are you aware?
It does.
It doesn't?
It does. At paragraph 10, this is Jackie.
Mr. Dunn, can you confirm that for me?
Yes, I can confirm that it does list that in paragraph 10.
You got the page number? Miss McLean, you got the page number?
Page,
Or
it's
Mr. Dunn?
page 3 of the out of 94.
In paragraph 10?
Yes.
Thank you, Mr. Dunn. Mr. Hearing Examiner, originally I thought we might need an amended exhibit packet, but I believe I'm mistaken. I think we should be fine as we are, Mr. Hearing Examiner. So I think we're good here.
Excellent. We'll take this case under advisement. Thank you. Let's move on to the last case on our docket, Spur Energy Partners. Entries of appearance, please.
Yes, Jackie McLean on behalf of Spur Energy Partners.
Thank you.
And in case number 25767, Spur seeks an order pulling all uncommitted interest in the Yeso formation in the east half of Section 2, Township 18 South, Range 27 East in Eddy County, and the unit will be dedicated to the Cheshire Cat State Com Wells. Our landman and geologist have previously testified before the division and are happy to answer any questions you might have. And I ask that the exhibits be admitted for case number 25767 and that the case be taken under advisement.
Thank you. Without exception, Ms. McLean. And your landman is who?
Marcus Westner.
Marcus. Let's get him on the screen. I have a feeling we have a question for him, right, Mr. McClure?
Mr. Hearing Examiner, I shouldn't have any questions for the expert. This is.
Okay.
Is it for Ms. McLean then?
Yeah, that's correct.
Thank you, Mr. Westner. Sorry. Go right ahead, Mr. McClure.
Thank you, Mr. Examiner. Ms. McLean, it appears that public notice was conducted November 20th. Is that correct?
Let me just double check. Yes, that's correct.
Is it also correct that public notice was needed to cure notice for this case?
You know, I think because of when the exhibits were due, and the deadline, when we sent out the notice letter, we hadn't received back all of the return receipts for, I think there was a couple of people who didn't receive that. But there's no, I think that was the only reason why we needed to do that. Let me just double check here.
Well, having said that, just to confirm that our notice is good, we may want to continue this to allow that notice to cure because it's 1 day out of date.
Oh, Thanksgiving. Okay, yes, you're correct. Can we just come back on the earliest date to allow?
December 18?
Yes, that's fine.
All right. Will you continue this case to December 18 so we can cure notice?
We can do that.
All right. Thank you, Ms. McLean. Mr. McClure, anything further?
Nothing from me, Mr. Examiner.
All right, Mr. McClure, thank you for a successful.
I have one item.
I thought it was going to be.
Ms. Hardy would like to talk about tater salad one more time.
Okay, what's that?
Okay, so the COG case 25712.
What number on the docket?
It's number 10 on the docket
10, thank you.
for the tater
Let me
salad.
call it again.
Balls.
This is 25712. We're back on the record. It was going to be continued to December 18. What's happening?
That's correct. And so the only matters that we were continuing for were to correct the checklist to change statewide setbacks to purple sage, which we can do quickly and easily. And the other was for COG to add on the exhibit A3, the breakdown of the COG entities that have ownership interests. And I have that information here and we can submit it today. I'm happy to show it on my screen if Mr. McClure would like, but it doesn't seem like it should be necessary to continue to December 18th, given those minor corrections.
Mr. McClure?
I mean, like any of the cases, we could conceivably look at their amendments in real time. I'm not sure if we have a reason to necessarily do so in this instance. I guess at your discretion, Mr. Examiner, I can review live for us.
And the reason I'm asking is that COG has this as a rig scheduled for these wells in February and is hoping to obtain an order sooner rather than later.
Okay, Mr. McClure, what did you ask to be corrected in this packet?
Originally, I requested that the setbacks on the CPAC be corrected, which is very straightforward. The other one, which you brought up, which is a good point, was for the breakout, essentially for the summary of interests of what percentage each one of the COG entities owns was the other one.
Ms. Hardy, the way I'm looking at this is, does it require further review? If it doesn't require further review, then I look at it as a typo. This, I think Mr. McClure would like to review.
Okay.
So since we are able to get it on a docket 2 weeks from today, and Mr. McClure now knows that you are seeking a quick review of this case. I think you've made it clear, and you can remind him again on the 18th of December. It doesn't seem to me that a 2-week delay would be fatal to your client. All right.
Understood.
But you know, it's fair to ask. It's a good representation. So thank you very much. We're off the record. We're done for the day.
Thank you.